is still with us in the studio. He's a legal practitioner, and we're discussing the twists and turns around the suspension of the Chief Justice of Nigeria, Justice Walter Onnoghen. Now, let's quickly look at some other perspectives. Now, you have talked about what should happen if the president should reinstate the CJN, and some people also believe that the CJN should step aside when he's reinstated. Do you also share that perspective?
Well, I'll confine myself to the legal issues. The legal issues are that the suspension was not properly done. The order, like I said, did not mandate the president to remove the CJN even temporarily. So those who feel that the proper thing to do will be to reverse the action taken may have a point. For the CJN, I think that it is left to him to decide, based on the past precedent, what to do when an accusation of this nature is made against him. Like you rightly mentioned, the instances of Justice Ongota and a few others who were also accused, who had to stop sitting and then eventually cleared their names and all that. So the fact is that the CJN will be in the best position to decide at this point, is it best for me after I've been reinstated to, step aside and face the allegations that are against me. But for the vast majority of lawyers, what is important is that the rule of law should be upheld. It should not be that one branch of government invades another branch of government, removes the head of that branch of government, and basically opens the country up to a situation which could lead to anarchy.
Well, as you said, a lot of people might share a perspective in that regard, especially in terms of the separation of powers and the fact that all arms of government are supposed to be equal and none should be, seen to be overreaching. But we've also heard about how the president of Nigeria is supposed to be the most powerful president in the world, and maybe this is part of what it is that you're talking about. But how do you think, now we're saying this, you're saying that the CCT is going to reconvene, yes, and we should hear them, give another date for adjournment. Yes. How do you think that trial will eventually proceed at the CCT?
Definitely, the matter was adjourned for the application challenging jurisdiction of the CCT. Whenever the CCT reconvenes, that is the application that is topmost. The courts have said consistently that when there is an application challenging the jurisdiction of a court, the court has jurisdiction to hear that application and must determine that application one way or the other first before proceeding further. We know that based on a similar challenge, the fact that there is a Court of Appeal decision that says that matters involving judges and their discipline should first be referred to the NJC. We know that based on that, this same CCT had, discharged a serving Supreme Court justice who was brought there without being referred to the NJC in the first place. So in this particular situation where the NJC has received the petition now and is beginning, to deal with it, like I said before, we have a very, we're in uncharted territory. We have a very difficult situation because the charges were filed at a time when the NJC had not been brought into the matter. So what should the court do in this circumstance? Should it go ahead and hear the application the way it stands? If it does that, of course, the likely outcome is that it would have to, hands off this until the NJC completes its assignment, and then it can decide whether, if fresh charges are brought, whether to take them on.
What do you think is on the trial here? Do you think the judiciary is the one on the trial, or do you think it is the executive?
Well, that's a very interesting question because when Mandela was put on trial, the Riviera trials in 1964 to 66, he made it very clear that it wasn't himself who was accused of militancy and all that was on trial. Now, what was on trial was the apartheid government of the day. So the judiciary is under attack, definitely. The rule of law is also under attack. But equally, the executive branch of government is on trial here. The question is, will it do the right thing? Don't forget that the CCT is actually a department of the presidency.
You don't think that the judiciary is under trial here?
Well, the judiciary is not necessarily under trial. One man has been charged, the Chief Justice of Nigeria. There's no allegation that the entire judiciary has done anything wrong. What we're simply saying is that this is an attack on the judiciary. It's an attempt by one arm of government unconstitutionally to take over and determine what happens in another arm of government. That is the sense in which the judiciary is under attack. But whether the judiciary is, on trial at this point, I wouldn't say that the judiciary is really on trial, but it's under attack.
I find it very interesting you say it's under trial. I mean, you believe that the executive is more under trial, that the judiciary is not even under any trial. When you look at the accusations of corruption that have been pervading the judiciary before now, I mean, remember the comments of the president, or even before even the president came into office, accusations, general accusations against the judiciary. And now you now find that the Chief Justice of Nigeria is being accused, rightly or wrongly, because they remain accusations. And, do you think, I mean, first and foremost, some people will say that that is an accusation that comes as a shock. For them, they believe that, like Caesar's wife, there should be no stain, no accusations whatsoever should stick against the CJN.
Exactly. The point is that Caesar's wife should be above suspicion. Does not mean that Caesar's wife cannot be accused. Okay? It depends on who is making the accusations and the basis for making those accusations. The fact is that the judiciary has been under scrutiny. There have been allegations of corruption in the judiciary. And those of us who are lawyers believe that what we need is a holistic approach to dealing with the issues of corruption in the judiciary, not a targeted approach which seems to pursue a particular line to achieve a particular purpose. What you should do is say, we need to clean our judiciary. What needs to be done? We need to hear from the ordinary citizens, many of whom have been, impacted by corruption in the judiciary. You need to hear from former judges who have sat and who have a reputation for being upright. We need to hear from judges in the bench. And then, at the end of the day, we need to take certain steps. That is how you clean the judiciary.
It is very sad, indeed, that this accusation has been made. And it is sad that accusations are also being made against the executive, that this is a selective fight, so to speak. And that we've seen, even the quickness with which it implemented this so-called order from the CCT, order that some people are still saying that they are investigating. And we've had lawyers say that they were there at the Code of Conduct Tribunal from morning till evening. They do not know when this order was eventually issued, and that they're investigating it. Some people have said that it is selective, but then some other people believe that it's not so much about the selectiveness. It's about, are you guilty? I mean, did you or did you not commit the offense? So if such an accusation is made, do you think that people ought to resign? We have also heard on the grounds of morality that people should resign when accusations are made, pending when it is that they can clear their name.
Yes, I think that if an accusation is made, it behoves on the person against whom the accusation is made to decide whether to resign or not. For example, if you have been falsely accused and you believe that you have done nothing wrong, it will be wrong simply because somebody accused you to resign. But there are circumstances where you are convinced as a person that I need not go through this. I need to just own up and admit that something went wrong here. So that is an obligation, a moral obligation that inheres on the individual. It is not a moral obligation that can be enforced. That is what we are saying. That's where the executive is wrong. They think it's a moral obligation and they can